three comments. I'm not going to take for every time. I think that the deposit immediately before the 200,000, that wasn't played up enough. I think that's very important from the defense's standpoint. You know, I don't know if you want to give an explanation for it or whatever you want to do, but I think that that's very important because I kept looking at it in the closing argument. I'm like, oh, well, that 155. You know, I mean, maybe you have to reconcile that. I don't know what you want to do with that, but you should play that up. Yeah, it could have been another bribe. I don't know. Something. Something. And also, the credibility of the witnesses. I don't think that that was tacked enough because the sister-in-law is testifying against somebody who she wants him to get him a job. She wants a job. Well, why are you testifying against him? You know, I think the defense, you should definitely, and then the assistant to Avery Bancroft, why are you testifying against your boss, or why are you, you know, making your boss look like, okay, you're trying to bribe somebody. So I know that would be the first thing, that's the first place I would go, is the credibility. Because that is in question, I didn't understand that. And the last thing I'll say is the length of the questions on the direct. I think that they have to be shorter. Now, there is a transition period. When you want to transition, yes, you can have a longer transition, but in between the transitions, you should have those open-ended, well, what if anything, or what happened, or what, and let your witness shine instead of repeating what they've said. Okay, so sometimes you may have to rearrange your direct so that it will signal to your witness where you're trying to go, but you still only want to say why, and tell us about that. And what happened next? You don't want to have your questions so long about, you know, because then it makes the jury go, and you want them to keep looking at your witness on direct examination. Let me see, did I have anything else? And also, and this is honestly the last thing. When you were doing, I'm sorry, I don't know your name. I have this stuff all together. Rebecca, okay. When you were doing the preliminary part, like the housekeeping matters, you were going really fast. And I know it's important information, so you want to slow down because it signals to the judge and the jury that these are important matters. So just slow down just a little bit. But I gave very detailed comments on on these pages. So, but that's all I'll say. But overall, it was very good. I enjoyed watching it.
Well, my name is John Mikulich. I'm a federal prosecutor with the Department of Justice in Washington, D.C. I've been a criminal prosecutor for over 35 years at various stages, state and federal level. I try white-collar crimes in federal district court all over the country, and I'm an adjunct professor of trial advocacy at Georgetown Law School. I guarantee you that all of you far outshine any of my students at the Georgetown Law School. Let that sink in for a moment. And you are also much better than most of the attorneys that we see in court every single day. I'm just blown away. First thing that blew me away is that you all have this stuff memorized. Are there instructors, coaches, and so forth in the class? Okay, for both teams.
We're student run. We're just an organization.
You just do this all yourselves, yeah. No coaching of any kind. Yeah. I'm sure you've been well coached, as some of the witnesses were well coached. But I'll leave that for another day. You're just I don't know if you're required to memorize or not, but it's just awesome. I don't know of any lawyers that can memorize all the questions of a direct examination, and I don't know of any lawyers who would take that risk. You know, because I know I'm going to forget something. I've never memorized a direct examination in my entire life. I've memorized openings and closings, but that's a different thing. You all were very good. I could spend the next 2 hours giving you feedback. We don't have that time. We're over time already now. But I just want to congratulate you all for a job very, very well done. Thank you.
Thank you. Thank you.
So my name is Eli Schleim. I'm an associate at a firm here in DC called Williams & Connolly, which is a litigation shop here in town. Sort of mid to senior level associate at this point. And I also did mock trial in college at Penn, competed for 4 years, and then at law school coach a high school team here in DC, which is something I highly encourage you all to think about as you go on. It's a really rewarding experience. It's something you can use some of your experiences here to help people. So I'll give you some thoughts I have as a competitor. Having done this for a while, I think you have to think about this as a game in many respects, and so my comments might be a little more geared towards that. The first thing I'd say is I personally am much more of a straight witness person than a character witness person. I'm guessing not real accents?
No, not at all.
Yeah. So my view on it, and I think the reason I emphasize this is because you never know what a judge's view is going to be. And so I think, and your coaches may tell you differently, but this is my advice that I'd like to give is you're always safer going with the straight witnesses than with a sort of character witness, because you never know what the judge is going to perceive it. And some judges love it, and so that's just my view on it. But in particular, and this I think goes to the credibility point, you really have to think about credibility. It seems very unusual that people would come into court and act sort of as cavalier as I think both, I don't mean to send you two out, but both of you sort of acted. And so even if you want to play a character, think about how that character would perform in court. It's a very serious thing. It comes down to something simple. I don't know, maybe we wear hats into a courtroom. I mean, it's just little things like that. Just think about, I understand the idea of acting, but just think about how some lawyers who are in court are going to be like, wait, that doesn't make any sense. And it does really come down to the credibility, because, and everyone I think needs to think more about attacking credibility and using the credibility to your benefit, right? So you guys have this witness who is living with the defendant, but you never really explained why she was testifying against him, which seems like a great fact for you, right? She's incredibly more credible to me because I'm just here doing my job. I'm trying to tell the truth, right? And I know it's going to hurt this guy. I know it's going to hurt my brother, but I understand I have to do it. And I would play it that way as opposed to the way you're playing it. So that's one point. Second, I completely agree with the point on how you're all using your themes. Obviously, themes are very important, but I would not start with your first sentence being the theme because it's very confusing to a jury and it is very abrupt. And you can just do it as simply as, the evidence is going to show that this was a bribe. You should follow the case in order, just something to bring in. It's a very weird thing to stand up and just make a declaratory statement to people, and it can be off-putting, I think. The other thing is, I think this is a very confusing case, and I was confused about all the different times and dates and meetings, and so I think you need to think about a better way to organize everything, and in particular on both of your closing arguments, thinking of better ways to give the jury a very clear timeline and a very clear structure on your part. And on your part, here are the 4 reasons that there's reasonable doubt. Your whole case is about reasonable doubt here, and there's enough of it, frankly, I think, right? I mean, their case is built on circumstantial evidence. No one saw them change cases, and I thought the point about the fingerprints is a great one, but do have responses. The other thing is you have to be very careful about the burden shifting. You frankly, I think you very well might have to do this trial. They have no burden. They do not have to bring evidence to trial. And by making an argument, well, why didn't they do something? You're getting very close to the line there, if not crossing the line. Which is just something, not something necessarily you should know, but something to think about. Maybe
Well, there is a way of doing it. Rather than saying you didn't bring in the evidence to show that you won the $155,000, and you didn't bring in the receipt or whatever, which was, I think, who crossed the defendant? You did? Yeah. You can say we haven't seen that, have we, in this trial?
Right, gotcha. Yeah.
We don't have an exhibit here to show the jury. To corroborate your testimony, do we, sir? Things like that. But that doesn't put the burden on the defense to bring it forward, because I think what Eli said is correct. There would have been a motion for a mistrial, and it would have been difficult to overcome because of that. We could talk about that forever. We just don't have time.
So let's just, I think your theme is actually not follow the case. I think your theme is follow the money. So I would just think that, and also, I mean, I like the pun, and I think really for lawyers as jurors, right, they like the idea of, oh, following a case, a legal case, right? But even on your closing, you kept jumping back and forth between case being a briefcase and case being your case. And so I would just think about it. Maybe I would think about follow the money, because you're really not, you're saying the money ends up in his bank account, right? I mean, that's the argument you're making. And so really, the money, here's this guy putting the money in the briefcase, it moves step by step, and I would really do a much better job I'm trying to do a better job of sort of explaining the steps, and then here it is in the bank account, right? So I would think about that as just another way to see it. And I think that's just catchy, right? People,
Can I add one thing to what you're saying?
Sure.
I think that another part, I didn't hear a story in your opening. And I think that's where the whole case, that's why everyone was confused, because the jury was not introduced to the story. On May 15th, this happened. There was a conversation. They gambled. And then on May 17th, he took a vote. And then on May 17th, the same thing, there was money. You're going to hear that there was money deposited. I didn't hear a story. So we were just waiting to hear the story through the witnesses, but you can't really sum up what the witnesses are going to say until closing. And then there was still no story in the closing. So think about putting the story.
Yeah, remember that we don't, I mean, you really,
We don't know.
What you really need to do is you need to step, and this is incredibly hard for the book, and I struggle with this whenever I'm preparing cases. You have to step out of it and imagine you know absolutely nothing, right? And the way to do this is talk to someone who knows nothing about it and make sure they understand it. But really, it was hard to put it all together.
Okay.
And I think also the other thing I'd say is think about on some of the examinations were a little bit odd in that, like, you would use demonstratives, like, why not use the bank account statement earlier, right? Like, there were times where I was like, well, I'm sure they have that blown up, but maybe it was you guys or someone, like, think about how you're using your demonstratives, and also, like, sometimes you would wait till redirect to ask, like, the key question. And I thought that was weird. And then the final thing I'll say is on cross-examinations, I thought across the board, pick your 3 or 4 key points and just do those. There were a lot of very good points made on cross, but they got lost because you were hitting on other things that were less important. Whereas, especially I think on the defense side, if you get up there and get a witness to give you your 3 reasonable doubt points, you just sit down. Right? Like, know when to think about when to sit down and think about how to declutter your crosses, because there's a lot of different facts going on in this case. And what are my 3 facts that I really want to hammer home? Because jurors can't keep that many things in their heads. And so you don't have to hit all the points.
Yeah, we were told last weekend to take advantage of the redirect or recross and maybe just get out that one last point so the jury just remembers that as the last thing.
I think that's exactly right, but I think there was at least 1 or 2 where I remember, I don't think I remember asking that question during the direct, or making that point during the direct, but I completely agree with you to use your redirect to make that last point. That's a great, that I agree. But I think you guys did do that. But sometimes it was, wait a second, why wasn't that more of an emphasis? I would have wished that the direct had just ended at that question, because that's what you needed, right? And it felt like, oh, I got lost, and you need to come back. So it's really just, you're refining things now. So just think about how you go, as you refine them, and just simplify them. You don't need to use all the time, I think is what they say on directs and crosses. Any other questions you had?
We go for individual comments?
Yeah, feel free to, if you want.
Thank you very much.